Welcome to the Hourly Podcast. Today, we're joined by Mary Claire Smith, an associate at Morris, Manning, and Martin Law Firm, and an expert on all things related to employment policy. Our discussion focuses on the recent changes to the FLSA salary threshold that have gone into effect July 1st. Mary Claire provides essential compliance advice that is relevant to anyone that employs non-exempt workers. Additionally, we share actionable tips on how to avoid significant labor cost increases associated with these new regulations. You can't afford to miss this one. Enjoy.
Thanks so much, Mary Claire, for joining. I'm so excited to spend some time with you today. As the CEO of Sprockets, we're working with thousands and thousands of operators that are nervous about new legislation that got in place yesterday, July 1st. The Fair Labor Standards Act. But before we get into that, tell me a little bit about you and your firm and some of the things that you deal with day to day.
Sure. And first of all, I'm thrilled to be here. Thank you for having me.
Of course.
This is my first podcast, so it's very exciting to be on. I've always wanted to be on a true crime podcast, but I'll have to settle for
Hopefully
later.
This doesn't turn into that.
No, definitely not. But yes, a little bit about myself and the firm I work with. I'm with Morris, Manning, and Martin. We are a full service firm in the Southeast, and based out of Atlanta and Washington, D.C. and North Carolina. I work in the employment group. So we specialize in employment and HR related matters, anything from wage and hour issues or employment discrimination issues. We advise employers on termination issues, restrictive covenants, a little bit of everything.
Got it. And then do you have any particular industries you work more with than others, or is it basically across the board?
It's pretty much across the board. A lot of our clients are smaller startup firms, but we also represent clients in the hospitality industry, hospitals, medical clients. It's very much across the board.
Wonderful. And so, given your position and of course, MMM being MMM, I'm assuming that the last couple of weeks have been a little crazy for you with this new legislation or newly, I don't know, was it called like appointed or put into action? I don't know the right word. But have you been crazy busy with that? And, talk to us a little bit about the basics. What is FLSA? And what are some of the implications high level that operators need to be concerned about moving forward into 2024 with their labor strategies?
Sure. So the FLSA is the Fair Labor Standards Act. And that is a law that's been enacted for a long time. It was enacted after the Great Depression. Basically, it's the law that governs minimum wage and overtime requirements. So you have employees. They're either going to be exempt or non-exempt under the FLSA. And what the FLSA means is that workers are going to be entitled to overtime if they work more than 40 hours a week. They should be getting paid time and a half for every hour worked over 40 hours a week. That applies to non-exempt employees. So if you're exempt, it means you're not subject to the FLSA's overtime requirements. And there's certain things that have to be in place in order to be classified as exempt. And what that means is you have to be paid on a salary basis instead of hourly. And you have to be paid a minimum salary each week on a salary basis. There's also certain duties you have to be performing to be classified as exempt. So it's a salary component and a duties component.
Got it. So if this law or act has been in action since the Great Depression, why are people talking about it right now? What's new about it that people need to know?
So the new regulation it's increasing the salary threshold to be classified as exempt. So the law has been in effect for a long time, but it just increases one component of it for the exempt classification. So again, I mentioned to be exempt, you have to be paid on a salary basis, and you have to be paid a certain amount a week. Right now, or before this act, that amount was $684 a week, which is the equivalent of a little over $35,000 a year. This new law increases the minimum salary requirement from $684 a week to $844, which means to be classified as exempt, you're going to have to be paid a salary of close to $44,000 a year annually.
Got it. And so, in the context for, let's say, restaurant owners, franchise operators that employ crew members, assistant managers, managers, director of ops, accountants, people in the front office, I know that that's a really broad kind of array of expertises, but in your experience, which of those people have changed from an employment perspective as it relates to this new rule?
So it's not going to directly affect your hourly employees. So, there's the people you talk about in your book, the frontline people, the servers,
Right.
the wait staff. It's not going to affect them. It's really going to affect your operations managers, your management level employees that are paid a salary and they're likely classified as exempt. And for the restaurant business in particular, a lot of those positions are paid a salary, but it's a lower salary in many cases. It's somewhere probably in that range of 35,000 to 50 grand a year. So it's going to affect those positions because employers are going to have to consider whether to increase their salaries in order to continue classifying those employees as exempt, such that they don't have to pay them overtime, or reclassify them as non-exempt. And then in which case they'll be subject to the overtime laws, meaning they'll have to be hourly employees and paid overtime for any hours worked over 40 a week.
Yeah. And so with these changes, what are some things that you're recommending to your clients of the speed in which they need to move to change and fix these things? And what are some action items that people can do to ensure that they maintain, this new level of being in compliance?
I think the biggest thing, the most important thing is to look at your exempt workforce. So look at those positions we just talked about, the management level employees, and work with legal counsel to determine whether those individuals are properly classified as exempt. Because again, it's not just the salary portion of the analysis. You have to look at their duties. Like, are they performing the duties of an exempt employee? So once you get past that, you want to look at, okay, they are properly classified as exempt. If they are, and they perform the duties of an exempt employee, then your organization is going to have to perform an analysis of, whether it makes sense financially to raise those salaries, to increase them so that they continue to be classified as exempt. And you have to balance, are you going to eat the costs in terms of increasing their salaries? Or if you reclassify them as non-exempt, understand that you're going to have to pay them overtime. So it's going to be a financial, but you're going to have to look at budgetary constraints and determine what makes the most sense for your company.
Got it. And this might be a super green question, but one that I'm thinking about, and other listeners may be too. Who polices this? Right? It kind of seems like overnight, there's been a change. Is there grace period to make the shift for operators? Is this a 911 for our listeners? How should they be thinking about it? And who's the governing body behind it all?
No, that's a very good question. So the governing body of the Fair Labor Standards Act is the Department of Labor.
Got it.
So that does raise a great question, because that is the federal governing body. So each state also has their own wage and hour laws, and state-specific DOLs will, Department of Labor's will look into this as well. And there's also state-specific requirements as to overtime and what it means to be exempt or not exempt. But, to answer your question more broadly, it would be the Department of Labor. And there's no specific grace period that we're aware of in terms of coming into compliance. But if an employee is found to be misclassified, so an employee that's classified as exempt and isn't truly exempt either because they don't meet the minimum salary threshold under the new law, or they're not performing the duties of an exempt employee, the employer could be liable for paying them back pay and certain penalties for misclassifying them.
Really interesting. And have you seen any of those penalties be incurred already, or do you anticipate not really hitting until Q3 and Q4? And the reason I'm asking is I'm thinking about all of the operators that we work with, and this might be the first time they've heard, just because they're busy, of the update. or they haven't gotten around to it. How pressing is this for their business? And what is the penalty if they wait any longer to make the shifts?
So the way you would see this come about is if an employee brought a claim. That would probably be the biggest example of how an employer could be penalized for this. The employee would have to bring some sort of wage and hour claim in court or pursue a lawsuit.
Right.
The Department of Labor also can go after an employer. They can do an investigation or an audit and find that they're not paying their employees correctly, an employer. But I think it's going to take some time for those sort of, to come into compliance, if that makes sense. And, you're not going to be on the DOL's radar because you haven't reclassified your employee and started paying them properly like a day after this legislation goes into effect.
But of course, the sooner the better, right?
Exactly.
Like hopefully those who are listening to this segment realizes the seriousness and the permanence of this, because they're not probably going to peel it back. This is going to be kind of the motion moving forward. So let's say I'm an operator, I have a few restaurants, I hear this podcast or this webinar, and I think to myself, oh no, I haven't thought about that. What is the first thing you would recommend I do to get back into compliance? Who do I call? What resources do I have to learn more? What are some things that I can accomplish in the next, let's say, week to try to get as compliant as quickly as possible?
I think the first thing, again, is to go back and look at your employees who are classified as exempt. Look at their salaries and determine what set of people don't meet this new salary threshold.
Yep.
And then the next thing would be consult with an employment lawyer. Look into those positions and are they properly classified? Do they meet the duties of an exempt employee? Because if they already don't meet those duties, chances are they should be reclassified as non-exempt anyway. And if they do meet those duties requirements, and it's important to continue having these positions be classified as exempt, you have to think seriously, are we going to raise the salaries of these individuals? And what is that going to look like for our company, for our business?
And, there's not a one size fit all. I know this is probably a very challenging question for you to answer with a mythical example. But what are you seeing most people doing? Are they raising the salary? Are they reclassifying? Like, talk to me about that. Like, what are some things to consider when making that decision?
I've seen several clients raise salaries, but again, I think it depends on what kind of business you're in, what kind of industry in, and what are these employees doing? Because some things to consider are, how is this going to affect your workforce? And how many employees are you looking at to raise the salaries for? If it's a significant amount of people, are you going to end up having to let go some other employees to free up some, finances to pay these people's salaries?
Yep.
And also another thing to consider is morale issues. When you reclassify somebody from exempt to non-exempt, they might view that as a demotion as well. So you have to think about the position. For the restaurant industries and hotel industries specifically, a lot of these managers that are classified as exempt, they view their position as, an opportunity for career growth with raises. But if you reclassify them as hourly, they may view that as a demotion and you telling them there's not a lot of room for growth for you here at this company.
Yeah, I mean, there's a lot to dig into there, right? And we know that those employees that feel empowered, see a career path, see a path towards out of hourly, are more likely to stay in their current position. So to your point, kind of pulling the rug from under them in some senses, saying, hey, now you're hourly, may be a blow to company culture, company morale, and you run the risk of losing those people, right? As if business isn't hard enough, right? You have to also manage that sort of thing. What other questions are you getting from particularly hospitality, restaurant, hotel owners in these first few weeks about the legislation and about the change? Anything notable to you?
Nothing notable beyond just, hey, look at these employee salaries and, who do I need to increase their salaries to comply with this new rule? And again, I think that's just, the obvious question. But as I keep saying, and I'm probably beating a dead horse here, you really have to go back and look at these positions and determine, should they be exempt anyway? Again, are they performing the duties of an exempt employee? Because you could end up spending all this money to increase the salary of the exempt employee, but again, they don't meet the duties threshold to be exempt, and you could still be on the hook for liability and penalties for misclassification.
And from your vantage point, why did they make the change? Like, was it more taxable income for the federal government? Is something happened in the market that required this sort of change? Like, maybe I should have started with this question, but what's the readout of why the change even occurred in the first place?
I think the DOL's position would be that it's to make sure employees are compensated for their work. So employees performing the job of an exempt employee, making judgment calls, exercising discretion,
Right.
that they are compensated for that work. And then there's also inflation and rising costs. This is to match, increased salaries.
Interesting. I mean, anything else? I mean, we knew that this was going to be around 15, 20 minutes. So we are at time. Any other things that you've told other clients or pieces of information you've been able to pass along to other organizations that have helped them in their journey in this transition that you'd like to share?
Yeah, I think some pointers other than, looking at these positions and making that determination of whether to reclassify or raise salaries is, if you do reclassify your employees as non-exempt, there's going to be some additional costs there to make sure that, these employees that are now all of a sudden going to be paid hourly, they understand how to comply with your timekeeping policies, and, making sure you're policing that and making sure your managers understand that employees need to work a certain amount of time before they get paid overtime. And looking at your handbook, for example, making sure there's language in there that requires hourly employees to ask permission before working overtime. So then you don't get slapped with a bunch of overtime pay when you're trying to do the right thing and reclassify employees to avoid the cost of increasing salaries.
Yeah, that makes a lot of sense. But if somebody wants to learn more about the firm, learn more about the new legislation, learn more about you, what's the best way for them to do that?
They should look at our website. It's morrisfanningandmartin.com. And we regularly send out client alerts as well. We did one recently on a post about this rule when it was proposed to be enacted back in April. And we'll be sending out other updates shortly too as well. We can always provide helpful tips in our articles about how to comply and what to look out for and how it might affect your business.
Great. And then outside of FLSA, my last question is, what are some other maybe things that are currently on the floor or things that you foresee coming as it pertains to labor that restaurant operators should keep a careful eye out for in the next few quarters?
I think the biggest topic is, I'm sure a lot of employers have heard about this, is the Federal Trade Commission's non-compete ban, which is set to go into effect in September. But there's several lawsuits seeking to block it. So the fate of it is yet to be determined, but we get questions almost every day about how, employers should comply with this non-compete ban with respect to existing employees that have non-competes in place.
Got it. And maybe as we get closer to that time, we'll hop on another podcast. But Mary Claire, really appreciate your time. Thank you so much. And looking forward to hearing how this all kind of plays out and staying in touch with you and the operators on the podcast. Thank you so much.
Thank you for having me.